It's not anything. No, you cannot. You can't convict me. Are you saying? It's not possible. I'm Nnamdi Kanu. Who's going to try it? Nobody can. They've not killed them dead to the person. Do something, you didn't do it. And you're just sitting computer. And you wonder why God cost you people. Useless black people. You don't know what justice means. You have no idea what justice means. You don't know what justice means. Useless black African people. You don't know the name of justice. Your constitution says you cannot try anybody unless the law is written. Show me the written law. Show me the written law. I want to know the written law. Show me the law. Are you okay? Don't go close. Don't try that rubbish. Don't try it. Don't try it. Go ahead and show. Don't try that rubbish. Don't try that rubbish. Useless people. You don't know law. You don't know law. Your own constitution you don't respect. Supreme Court's judgment you don't respect. Then why are we in the court of law? Why are we in the court of law, I ask? Nonsense. You think Britain can ask you to jail me and you jail me? You are dreaming. You are dreaming. I'm telling you that you are dreaming.
That exactly was what happened in court yesterday, and I understand we're being joined by a legal practitioner right now, and I'm excited about that because I want to hear his perspective, particularly in the part of the law. And I'm talking about Barrister Eze Luche, legal practitioner, of course, political affairs analyst as well. Barrister, thank you so very much for joining the conversation this morning.
For the invite.
Thank you so very much. Well, let's have your view about all that has transpired with Mazi Nnamdi Kanu, plus what happened yesterday in court, and of course, the date set for his judgment. What's your position in all of this?
Thank you very much. The reality is that when Nnamdi Kanu sacked or disengaged his legal team, some of us felt that was a proper and wise thing to do because this was a political case, not a legal case. And if the lawyers were there, they will be restricted or bound by certain rules and ethics that will not allow the essence of the case to be brought to the fore. It was such that if Nnamdi Kanu defended himself, we had hoped, looked forward to the proper issues being brought to the fore. But when he now failed to enter his defense, he first of all reeled out the list of witnesses, right, which also excited a lot of people because when he listed some governors, ministers, it was exciting because the issue of their privilege or immunity would have come to play. Some of us believe that they don't have immunity to the extent of not coming to court. Because if you remember, governors, when they are about to be impeached, they do actually file processes, which means that their immunity or has some kind of restraints. Now, when he said he was not going to defend himself, that was when some of us got worried. Because even in the Bible, before God condemned Adam, he asked him questions and Adam had to reply. There is a fundamental rule in justice. Audi authorem patem, both sides must be heard. Okay. In this instance, Nnamdi Kanu was given an opportunity to be heard. And rather than even say something or enter a defense, he blacked out. He denied, he said he was not going to enter a defense. That was a very fatal error on his part.
Now, when you say that's a fatal error, Barrister Ezeluche, can you help Nigerians understand the, Section 36, subsection 12 of the 1999 Constitution as was amended? Because there, the man, when, there in the dock, made a statement arguing that there was no written law establishing terrorism as an offense in Nigeria. Please help Nigerians understand this as a legal practitioner.
Well, he's wrong because there's an offense of terrorism. Moreover, Nigeria has signed a lot of international instruments where terrorism is also one of the offenses. So he cannot say that there's no offense called terrorism. It is an offense. That was why I said he erred. He should have, at that stage, taken the advice of the judge and sought legal advice, not legal representation. Those are two different things. He could have asked for lawyers to properly address him whether there was an offense for terrorism. There is an offense for terrorism. People have been charged and are undergoing trials presently for terrorism. If you remember, Asari Dokubo was charged for terrorism, and there are other people who have been charged who are facing trials now for terrorism. So it was a very wrong move of him to say it is not written.
So explicitly, what does the Constitution say?
He may not know where the law is.
What does the Constitution say on that particular clause? I'm talking about Section 36, subsection 12 of our Constitution. What does that actually say? So that, people who are already judging bringing up their judgment based on emotion and sentiment will understand the words of the Constitution.
Clearly laid out in layman's language so we understand as well.
36 means that it gives you a right of fair hearing. That 6.2 says that you can only be tried based on a written law. So if he might not be aware of where the law is written, but that does not mean that there is no law on terrorism. So Nigerians, there is a law on terrorism for which people have been tried and have been tried. So it was an error on Nnamdi Kanu's part to say.
So barrister, so sorry to butt here. Where exactly is the law written in the Constitution? Which again is his concern?
No, the law will not be written in the Constitution. What the Constitution will provide is that you must be tried under a written law, and there are several laws, like for instance, the Cybercrime Act contains crimes on cyber security issues. It is not in the Constitution, but it's in a different law. And there's the Terrorism Act, which contains the crimes on terrorism. His error was that he was thinking that the crime of terrorism will be in the Constitution. No, there is no such provision. But the laws are there for this act. And not all the crimes are incorporated in the Constitution. But the Constitution is a ground norm. It tells you that whatever you are being charged for, there must be a written law. That Nnamdi Kanu is not aware of the written law does not mean there's no written law. That is where he erred.
So is there the possibility? Is there the possibility, barrister, that his representatives before now, and I'm talking about Barrister Gabi, SAN, would have not told him before now that there is a law, particularly on terrorism?
No, the reality is this. He has disengaged his lawyers, so we cannot now begin to guess what the lawyers told him or what they've been telling.
All right, now.
But even at this stage, the judge asked him to seek legal opinion, not legal representation. Because when he was making that noise that there was no law on terrorism, the law was not written, he should have sought legal opinions. So, look, the reality is this. The fact that the court gave him 6 days to even enter a defense, he should have started a defense. It was clear that there was no justice in this case. If he had commenced his defense and then let the court rule him out that you have only spent 2 or 3 days, you are out, you are ruled out, it will be clear as injustice. But in this instance, unfortunately for him, he has not even bothered to enter any defense.
Now that he has lost
the withdrawal of his not guilty plea, which is, the problem Mr. Nnamdi Kanu has is he did not seek advice, and he has this mindset of all-knowing. And I don't know whether his days in captivity in the DSS cells has affected his reasoning. But when you even watch the video, His countenance, his approach was below par. There was no need to get that violent in court. The cause Mr. Nnamdi Kanu is fighting for is a very worthy cause and a universal cause, the cause of self-determination. Now, to conflict or to confuse that issue with the kind of mannerisms he displayed was rather unfortunate.
All right, Barrister, now that he has lost his...
that he might have stayed too long and then things are happening that he's not really in control of.
All right, now that he has lost or forfeited his right to bring in defense or open a defense, as the case may be, and with the Justice James Omotosho pushing the judgment to be on 20th of November, what does this really portend? You know, I'm talking about the back and forth, and also the fact that he first of all asked the court to subpoena the people that he made mention of to be his witnesses, later pulling it out, and every other thing that transpired after that, to the point of losing or forfeiting his right to defense. What does this portend for, you know, the young man in DSS detention?
Well, the reality is this. After the close of the prosecution's case, his lawyers filed a no case submission. And the court said, no, you have a case to answer. That means at that stage, in the judge's opinion, there was already a case, a guilty verdict actually, because he has a case to answer. Now, his failure to enter defense, and now the court has said it will give judgment. Judgment based on the opinion the court has already formed at the end of the prosecution. So you don't need to be a nuclear scientist to realize that most likely there will be a guilty verdict. I mean, that is just the reality. There will be a guilty verdict, there will be a sentence, and then, like I said from the onset, this is a political case. If to down detention, we will expect maybe consideration for pardon and other things. But on technically speaking, considering that the judge, Justice James Omotosho, had ruled that there was a case to answer at the onset, at the end of the prosecution's case, and that there was no defense whatsoever, that means that case, that belief or perception of the judge that there's a case to answer still remains, has not been in any way obscured or obviated. And if that same notion still rings true in the judge's mind, that means there will be most likely a guilt verdict. But that is, I'm not the judge. The judge still knows what he will say. Yes.
All right. Thank you so much, Barrister Isaluche. Let's bring it to the